I'm here this morning with Chris Byrd once again. Chris, you've been working with, or been involved with ALAC, American Laws for American Courts. What is the current status as of today with that particular bill?
Well, Kat, very regrettably, it stalled out last Sunday night, actually around 11 o'clock. The calendar committee had been brought together for the final consideration of the latest round of bills to be posted on the floor for vote. And it ended up in a deadlock because we had two Republican co-authors, who were both women, interestingly enough, decide to flip-flop at the very last minute, and explanations not really provided. We have learned more now, but they were paid, or at least one was paid a visit by one of the lobbying groups earlier in the day. So they flip-flopped their position, which then caused the measure to be in a deadlock, and it wasn't able to get posted on the floor. I'm told that the committee chair, Representative Todd Hunter, was making every effort on his end to get it out of that committee and positioned in the calendars in such a way so that it would in fact receive a time on the floor to be voted on. So it's very regrettably, after all this work and time, and I'm speaking here specifically of Senate Bill 531.
Thank you, yes.
And its mirror language is House Bill 562. That same committee had actually voted that same bill out weeks ago. So we have these two Republican women that switched their positions at the last minute, voted with the Democrats, and put it in a deadlock, and so it didn't get voted on. It's not going to be this session.
Any speculation about a special session that it might get any legwork there?
We've inquired about that. One thing that was pointed out to me was these special sessions are extremely expensive. And if you think about it, it makes sense, because all the workings and trappings that go on in the Capitol, they have to continue. Mm-hmm. Of course, the lawmakers are called to be there for extended periods of time. It's at great expense, and I'm told that there's not any plans on our governor's part to extend the session. He had forecasted recently the bills that were important to him. Yes. And this was not one of those, and so it did not get the encouragement from his office, or else the possibility existed for, if those bills weren't dealt with, to be the subject of an extended session.
This bill is a very important bill, American Laws for American Courts. We visited before, but for those who have not heard our previous interview, you gave a recent example of a couple in Houston and how it was a good example of why it's necessary for American laws to be the one we go by. Would you mind sharing that again?
Not at all. It's a recent case. We learned about it literally days before the contested hearings in the Senate, on the floor, in fact. The Senate State Affairs Committee is the one that approved Senate Bill 531, but during those hearings, this case came up, and it had been released by the Court of Appeals out of Houston just days earlier. What happened there is the Ashfaq case. It's ASHFAQ, so I'm assuming I'm pronouncing it right.
I'll go with your pronunciation.
but basically, you have a Pakistani citizen woman that had been a resident of Texas for a couple of years, had moved to Texas to be with her husband. She'd married him in Pakistan, and she was working on getting her citizenship. He was a dual citizen of Pakistan and the United States, and so They went back home to Pakistan to visit family, respective parents, and of all things to attend a wedding. And there, while she was staying with her parents, a messenger came to hand her talaq divorce certificate. Now, Pakistan's civil code, which is a Sharia-backed, Sharia law-inspired civil code, I'll call it that, does afford a man and a man only. It's not an equal protection,
Right.
or we might argue equal opportunity here. It doesn't extend to the woman, but the man can divorce his wife very simply, without notice. She didn't have any notice, and that she was divorced he announces 3 times, "I divorce you," and then he gets, in some cases, a certificate of divorce from a local authority, and then she was served with that. So she came back home to Houston, and later learned that he had, in the interim, married another woman from Pakistan. He had worked with the Obama administration in getting her into the States on a visa, and so he had to prove up that he was not bringing in a second wife.
Oh, wow.
And so the administration looked at the talaq divorce situation and considered him, for purposes of her visa request, to be divorced. So they allowed her in. That actually, I mentioned that because that was a component of evidence that the trial court judge in Houston later relied upon. When she came in and asked for a divorce, her husband, I'll maintain, came in and said, "Well, Judge, we're already divorced. Here's my talaq divorce certificate." And the judge honored that, and then we learned the Court of Appeals upheld that and honored that as well. So it's a horrible outcome for her. And you might ask, well, Chris, she filed for divorce. What's the difference? You know, what difference does it make whether that happens in Pakistan or happens in Houston? Why do you care? And I care because of the precedents that it sets. It sets a legal standard of conduct which cannot be reconciled to any of our laws. It cannot be reconciled to due process, equal protection, specifically. And of course, in family law with a divorce situation, the conduct of the parties does have a great bearing on, once that's unfolded and before a court, that has a great bearing on things like division of assets and potentially child support indirectly, and certainly spousal maintenance and other factors. And so there are religious factors as well. Some people will still today claim adultery for religious reasons so that they'll get a finding for that. Well, all of that is swept away with a talaq divorce, and of course it's a one-way analysis because I divorce you 3 times and that's that.
Mm. So with this coming in, or maybe not coming in, might not be the right wording, but happening more in our courts and specifically here in Texas, what do we need to do to begin to make more people aware and to kind of push the tide the other direction?
Well, when it comes to the debate of American law for American courts, the strongest argument that you'll hear against it is, well, it's just not needed. And so then you might get a concession there and say, well, it's happening in other states, but it's not happening in Texas. So let's wait until it happens in Texas before we examine whether or not we actually need to look into this, because after all, we're Texas. I've heard so many times, even from lawmakers, this is not going to happen on my watch. This is Texas. Well, the fact of the matter is that it is happening.
Yes.
We've got a bad case back in 2003 where a woman was subjected to a contract to enter into an arbitration decision, and during a pending divorce involving children and assets disputes, all of those justiciable matters were removed from the trial court judge, and put squarely in front of the Texas Islamic Court in Richardson, Texas, applying Islamic law. And so they came back, she lost everything and became the obligor and lost the custody of her children. And the trial court judge reversed all that, and then he was reversed by the Court of Appeals in Fort Worth, and that was in 2003, and I had visited with him on several occasions. He is still upset about that decision.
Right.
He's told me personally, Chris.
That being the judge.
Yes,
Yeah.
and that's correct. And he's told me personally, if she just appealed it to the Supreme Court, I'm certain it would have been reversed. But the problem is people say that so flippantly. Do you have any idea how much money it takes to appeal from a trial court just to appellate court, and then from the appellate court to the Supreme Court, and then to go and argue that and to lay that out and to finance that litigation for extended periods of time? It's extremely expensive. And she ran out of the gas on that, so to speak.
With the arguments and all that you heard in Austin, what were some of the reasons that this didn't get the ground that it needed to keep moving forward? What were some of the arguments, the pushback on this?
Well, the pushback is coming from several directions. The one that I hear a lot is a First Amendment argument, basically saying, well, this bill, which basically says this: Judge, you may not apply or enforce foreign law to adjudicate, resolve, judicial, enter a judgment on a dispute involving either the marriage or parent-child relationship. You may not apply or enforce foreign law to do that if it would not guarantee fundamental constitutional rights.
Right.
Now that seems pretty straightforward to me.
I think so.
That does not seem to involve anything religious in nature. Yet we have a large contingent of Muslims bringing forth, well, this is focused at us. This is the anti-Sharia bill, and this keeps us from practicing our religion. Well, let's go and examine the Ashfaq case. And I said a minute ago that the Pakistan Civil Code is a civil code that is Sharia law inspired. Well, we all know that Sharia is the Islamic law, and it extends to all walks of life. And so to be Sharia compliant, you're actually practicing your religion in that regard. It's unlike ours. In other words, if you simply maintain compliance with our civil code, you're not at the same time practicing a certain religion. You follow me?
True, yes.
But in their minds, they are. And so that's the linkage where they say, well, if you keep us from practicing our religion, now you violated First Amendment.
But isn't the majority of the Sharia law more a form of government as opposed to faith?
I wouldn't call it that so much. I would say that the majority of Sharia is more or less jihad. It's more or less compliance driven, as opposed to worship driven. Now that's my personal opinion.
Okay.
Others might disagree. But back to your question, I hear First Amendment conversations and arguments. And my retort to that is first of all, this law is completely religious neutral. It would apply to a bad decision that we see from time to time. We haven't had one in Texas yet, where a judge might draw inspiration from the Convention on the Rights of the Child. That's bad law. 192 foreign nations have signed on to it, but us, we have not. And we find instances where that creeps into the courtroom and it's applied. Well, this law would apply to
Protect
that.
that as well, okay.
That's got nothing to do with religion. We see from time to time missionaries, for example, in the family setting that find themselves in a foreign land for extended periods of time. There are many countries that are on the UN watch list for gender equality improvement. The gender inequality is not necessarily religious based. That's just their culture. And so it kind of stands to reason if you presuppose that the United States has over time developed probably the finest jurisprudence and civil codes in the world ever known for rights and so forth. And I would say in regards to that First Amendment argument, well, you're not going to be able to practice your religion as you call it if in the same time it is eroding or dissolving everyone else's rights. And see, that's one of the things that Sharia is about. Another argument that I hear is that it's just not needed, like I was telling you earlier, but we're seeing absolutely that it is needed, and we need to get ahead of the problem instead of trying to catch up to it.
Well, it conflicts with the Constitution, so doesn't the Constitution need to override and supersede any other laws?
That's a good point. Article 6 of the Constitution states, and I'm pretty sure I'm quoting it, is that the Constitution and the laws of the states shall be the supreme law of the land and shall apply to every judge. And it goes on to mention the lawmakers. And yes, it should, but here we are dealing in a situation of conflict of laws, where you've got the laws of a foreign nation that are either by contract or simply by an enforcement question. Do we enforce them or do we not? Mm-hmm. So I had a case myself where a U.S. military serviceman married a German professor, and they got divorced in Germany. Now I had to enforce that divorce decree here in Texas. So there is where foreign law is considered by a local judge. Mm-hmm. But we already know that in Germany, they do embrace and practice basic constitutional fundamental rights. They do today. Okay. Now there was a time not too long ago where they certainly did not. But today the fundamental concepts of equal protection and due process are there. And of course in that instance you can proceed in enforcing that. So we're in a fuzzy area where we're forced to deal with foreign law, and it's a conflict of law type of area, and we don't have very many cases on our own Supreme Court in Texas. In the Gutierrez case and the Duncan-Cessna case has called out our legislature and said, we don't have any cases, we don't have any civil laws that direct our judges on what to do. We're going to adopt the second restatement of conflicts of laws, and we're going to call on you to pass legislation to give our judges direction. And that's where we are. And Senate Bill 531 would have answered that, as well as House Bill 562.
So we have fuzzy law.
Well,
we have 2 years to prepare for the next session. What do we do?
Well, the fuzzy law comment is basically to say that in the area of conflicts of law, we don't have much case law to go on, and we don't have any legislative law that gives our judges the direction that is needed. Mm-hmm. In like the Ashfac case. And let's just take that for example.
That's now a case law, wouldn't it be? That could be used against.
Unless it gets appealed and reversed by the Supremes, it will be that law, and incidentally it's in direct conflict with the decision that was rendered 20 years ago in Fort Worth by the appellate court in the Seth case. That court specifically said that these ex parte talent divorces are against good morals and public policy, so much so that they're invalid. The American Bar Association 4 years ago came out with a report and stated that these discordant laws that are Sharia-backed are in many instances discriminatory against women and may in fact not only be invalid but be illegal under our codes, under our laws. So we need the legislation to say, take the Ashfac case for example, had that legislation been in place, the litigant, represented by an attorney, would have raised that bill up and said, Judge, you cannot apply or enforce this foreign order if in doing so it violates fundamental constitutional rights, and they clearly were violated.
Yeah.
Did I answer your question, or did
I
I
think you
answer another
Well, I
question?
think you did. I think you did, but I guess it's unfortunately, and I'm sure you feel the same way. It's left everything in limbo. So it's like, if we were going to do a call to action? Where do we go now? How do we begin preparing so that this will get taken care of next time?
Yeah, I think I did not answer your question completely. I remember more of it now, and it's basically next steps. What do we do? Where do we go from here?
Yeah.
And of course, as you know, it's going to be a little bit longer than a year and a half before the session comes back. Our lawmakers come back together and begin another session. I think we're probably at a state of affairs in Texas now. We probably need a session every year.
I think
That'd
so.
be my opinion, but that's just my opinion.
I think so too. I agree.
And so, well, the obvious intent by our state framers was to make a statement. Look, we're about liberty in Texas. We don't want you folks going to the Capitol and making laws every year or all year, So I think the premise probably was chances are more bad will come from it than good.
But it's also ridiculous to have 7,000 bills for them to hear, and while they may have a 140-day session, it all comes down to like the last 30 when everything's trying to get pushed through, and that's ridiculous.
And even this week is quite the frenzy, if you pay any attention to it. So, but to your question, we are going to have to continue what we've been doing. There's been an enormous amount of awareness that has been planted. The seeds have been planted. Grassroots groups are forming. Even amongst the Democrats, we've made a lot of inroads in this because they understand it to be a women's rights issue, and they're right about that. Now, I'm not championing the bill. That's the byproduct, of course. But my passion is that it's an erosion of liberty for everybody.
Yes.
Men and women included. Now, if you look at the numbers, obviously the preponderance of the benefactors of enforcing that proposed legislation would certainly be to enforce or protect women's rights. But the Constitution's for everybody, of course, and so we need to continue our awareness. We need to, I think, that we ought to make this, you mentioned the Republican convention before we started a minute ago. I think we need to make this a plank.
Be very good.
I think we need to make American law for American courts, or call it Texas law for Texas courts. I don't really care.
Yeah, exactly.
But put it on the plank, get it voted on by the Republicans, and make it, I think was there 10 right now that are your core?
I think it's about 10. I think you're right.
And this needs to be a core principle plank, in my opinion.
That's a very good thought, yes.
And we need to fight that fight and get it on there officially. We need to continue to energize, motivate, equip grassroots with information, speaking points, and demanding, not relenting, absolutely demanding nothing short of support by all lawmakers.
Yeah.
And if you're not going to support American law for American courts, well, it would drive to me personally a question: do you really need to be considered worthy of an oath of office? Same for our judges.
Yes.
We now are starting.
We've got elections coming in between. We need to look at who's running.
We need to look at our judges. We need to be asking them these questions. Judge, how do you feel about this? Have you read that legislation? And I would say to any judge at this point in time, if they haven't even read it, or they're not keeping up with it, because this is a cutting edge issue.
Yes.
Well, you've got a judge that's probably not paying attention to cutting edge issues. Do you want that kind of a judge on the bench? Do you want the kind of judges that will sit there and do what we have seen in some of these cases? We've seen a few. We don't have a silver bullet case, thankfully, in Texas, and I'm not wanting one. there are certainly silver bullet cases elsewhere. And I don't want one here in Texas, but do you want a judge to sit there and not know what this is about and to ponder if when the question comes to them, well, maybe I can just legislate from the bench?
No,
I'm not in favor of that.
no. And don't they swear their allegiance as to become a judge to the Constitution, not to these other laws and all?
You know, I guess I've been immersed in this for too long because I tend to lose some of that oversight. But yes, I mean, obviously, when you do swear yourself in oath to become a judge, I was one, and I had to take an oath. And absolutely, you have to take an oath to uphold the Constitution. So, incidentally, that includes Article 6.
You were talking about some of the pushback came from some of the Muslim organizations
Yes.
that were, so they are actively lobbying at our Capitol.
Oh, there's no question about it, and they've got some allies. This year there was a big push that came from the Texas Family Law Foundation, and the posturing that I could see, the best I could tell, is that they represented themselves to be representing the State Bar of Texas. Well, they don't. I'm a member of the State Bar of Texas, and I am unaware that whatever they elect to do, that small band of attorneys in that instance are speaking for me and the rest of the attorneys in the state. They've aligned their positioning on this issue with CARE.
That's, okay.
And CARE is a known terrorist group. I believe they've got very strong known ties to Hamas and some of the others. They're clearly one of the leading organizations in the Muslim Brotherhood. They were found to be one of the unindicted co-conspirators in the Holy Land Foundation trials in 2008, where the Bush administration prosecuted the Holy Land Foundation, which, and they were going down the list, and CARE is on that list, found by that court to be an unindicted co-conspirator. Since that time, the UAE has even come out very recently and named them to be a terrorist organization, and I need to look into this, but I heard the other day that a federal judge just recently did as well. There's no question about it, and why we would allow a terrorist organization onto the state capitol grounds to begin to tell us, to tell our lawmakers how they should ponder and decide on issues of any kind, much less issues surrounding our Constitution, is beyond me.
Were there some specific legislators, both either in the House or the Senate, that seemed to be aligning themselves with that organization?
Well, the two I mentioned to start with that flopped last Sunday night, that stalled this bill. Had this bill gotten out of calendars, it would have very possibly been voted into law by now as we sit here on Tuesday. And certainly it was being postured to be voted on this week. And those are Representatives Debbie Riddle and Patricia Harless. Now we've got other lawmakers that were objectors along the way. We had one Republican senator, that would be Senator Estes. He was a strong opponent against this.
What was his argument against it?
His argument was that a bill that he had authored and now became law 4 years ago took care of all these problems.
Oh, really?
Took care of every one of these problems. Now there certainly is no need. And when you look at his bill, which is Senate Bill 1216, you begin to quickly learn that it is limited. It is limited to the one circumstance where a litigant, to any kind of an issue, not family law related, but just any kind of an issue, who find that they are the subject of an agreement to go arbitrate, may at any time decide to question whether that agreement is void or voidable, and basically raise a flag and say, I'm not proceeding and based on 1216, I don't have to proceed, and I'm gonna go to the judge and I'm gonna ask the judge if this contract to force me to arbitrate is valid. Now that's got nothing to do with foreign laws or the Constitution. It's strictly an opportunity to say, I'm gonna hold off here on this arbitration until this judge tells me that I have to per this contract, or I don't have to. And according to Senator Estes, that takes care of the problem.
That didn't address anything to the other.
Well, it's a head scratcher.
Yeah, exactly. Any other particular things you discovered while you were working at the Capitol that would be of interest?
I have seen a lot of involvement by a lot of folks. Eagle Forum has really stepped up and has developed a lot of leadership and organization on this. A grassroots committee or group all over the state.
Mm-hmm.
The Concerned Women for America is
Yes.
another group. I believe we're going to start to see some pretty good noise come from the Federation of Republican Women as well. Each of these small clubs, you know, that are 20 to 150, in some cases larger.
Mm-hmm.
I think there's a very large one in Midland. We're going to start to hear from those women. And I've actually gone on record to say that one of the things that it may come to get this stopped dead in its tracks is the Texas woman.
Of course. Well, it is, you know, the example you gave, it is definitely a woman's right, and also protects the children as well. Because under some countries' laws, if I remember correctly, it's automatically the children go with the man. And that doesn't line up with our Constitution either.
No, and it's interesting you brought that up, but that was a point that Judge Sullivan made to me in the Jabri case. He said, Chris, do you realize that there is no best interest standard under Texas Islamic law? Do you realize that Texas Islamic court didn't apply the Texas best interest standard for the children? That bothers me, Chris. And he was greatly disturbed about that fact. And yes, that, you know, you certainly could argue that the children are very much overlooked. When you don't have a judge being held to a best interest standard in determining the environs that child is going to find themselves in, it's horrible. It's horrible. And yes, those are rights. They're different than what we normally think of as constitutional rights, but they are rights. And children deserve to have a objective decision maker consider what's in their best interest.
Well, a lot of these children were born Americans, are not just necessarily immigrants, and so they should be under the Constitution. That's what drives so many of them here, is what makes America America.
Well, you're making me think of an issue here, because I'm going to maintain that any person that once they set foot on Texas soil, whether they're a citizen or a resident only, they deserve the safe haven of all of our laws. And I say that because that's another argument that I hear. Well, Chris, they're not from here. They're from there. And in fact, during testimony, the woman from CARE actually made the statement, we're peaceful, all we want is to be able to live by our laws. She actually made that statement on the Senate floor. Well, I'm sorry, your laws can't be reconciled to ours. And don't suggest that they can, because they simply cannot. Now, you made a point a minute ago about in best interest, you know, that some places, you know, the child has to be with father. Well, you might be interested to know, we do have a case in Texas involving an Egyptian issue where we had a man from Texas married a woman from Egypt. They had 2 children. They decided to get a divorce. She files for divorce in Egypt. He files for divorce in Texas in that order. And the judge in Texas decides to not take the case because of the procedural issues and the jurisdictional question about the fact that she filed first and she was in Egypt, but the judge knew that in Egypt it was irrebuttable, an irrebuttable presumption of law that the best interest for the child was to remain with mom until the age of 10, whether it's a girl or a boy. So there you've got gender inequality in reverse.
Well,
and it's not just Egypt, but I'll note also Egypt's civil code is not Sharia backed. That's just their culture. So we see it both ways, and that's why I feel very much that our own laws have examined these issues and have come squarely down on what's the right thing to do. We're not perfect.
no.
We've got lots of refinement to make, but our motivation, our sights are on trying to get to that place where fairness is really one of the basic fundamental concepts that we're trying to adhere to.
Well, we've become such a melting pot that if we have everyone's laws from all these other countries and religions and all come in, then anything will go. And that won't work.
No, it will not work. And we do have other nations that are now dealing with that. In England, for example, there are 32 different Sharia court zones. They are processing cases of all varieties involving, to one extent, about 15% concerning non-Muslims.
Oh my.
And I'm not just talking about family law related matters. I'm talking about probate, criminal, contractual, real estate, finance, financial. There is Sharia finance. There's a lot of compliance with Sharia on the finance side.
So is there a warning there, because as they allowed it more and more to grow and get stronger in their country, that now it's becoming an issue?
Oh, well, I would argue that the cake is already baked on that. But, you know, they finally woke up just recently. The House of Lords.
But our warning to look at them as an example
Of course.
of where we don't want to go.
No, that's exactly right. But I will tell you that the House of Lords in England just recently decided to wake up and say, you know what, we got a problem here. Let's do this. Let's sanction an official government-run. We'll do a website. We'll do a website. We'll put all this information on the web for the world to see. Let's call it Sharia Watch UK. How about that?
And the result?
Well, we've got a website now in England called Sharia Watch UK, sanctioned by the House of Lords. Now here there is a Sharia Watch USA, and there's a Facebook, Sharia Watch USA.
Who's behind that here in the U.S.?
Here in Texas, well, we were very fortunate to secure those rights.
Oh, okay. Okay. Any last thoughts on this? I mean, we could talk for hours on this because there's answers still to be found on how we stop this and change it and preserve what's right.
Well, you know, I think that, and I've been reminded, Chris, please keep in mind that freedom of religion is one of the basic fundamental concepts that Americans have become to be known for. It's one of the reasons our country was founded. And so that's what makes this complicated in some cases, because you've got a confusion, as I alluded to earlier, that this is about exercise of religion. It's not. This is about creating, to your point, creating an alternative system of laws, an alternative parallel judicial system, like is what is in England. It is true to say that if that is done, some people will be exercising or practicing their religion. It is true to say that the unfolding of that, the material development of that, by those that want that to happen, they will be exercising their religion.
ISIS is exercising their religion.
ISIS is exercising their religion. But as I'm finding out, this isn't the first time we've dealt with this issue. You know, this issue goes back to before when we became even a constitutional nation. This issue came on us the minute that we defeated the English and fell outside the protection of the contract that they had with the 4 Muslim Barbary states, and we began to have our ships and men and women and goods captured and destroyed and so forth. Even John Quincy Adams made the statement that Muhammad has declared an undistinguishing and exterminating war as part of his religion against all mankind until they submit and acknowledge that he is the divine prophet of Allah, and so on and so on. You might want to take a look at some of the other comments from John Quincy Adams, as well as his father, John Adams, as well as Winston Churchill, as well as Thomas Jefferson, and some of our other founding fathers. Those positions are well documented in the annals of Congress. And, you know, remarkably, they weren't in my textbook when I was
No, that's a whole other topic too. But is there a way, because the way the Quran, the Hadith, the Book of Muhammad, all of that is written and focused, and the majority of it is more government law and things along that line. Is there a way for, in our American laws, to separate it from what we would consider the faith side, so we can deal with it? I know, I threw out a big question here at the end, sorry.
Is there a way that we can separate out, you know?
Because that's the issue, as you're saying, that's the...
Well, I don't know that it is. You know, I just don't think that it's possible to cherry pick out of those various sources of religious doctrine the concepts which are purely, admittedly, exclusively religious in nature.
Mm-hmm.
Some research indicates that out of the entire body of Sharia, maybe as much as 14% is religious in nature.
Exactly.
And the rest of it is, you call it government related, I might call it Sharia compliance related, I might also call it to be jihad related. It's the response as to what to do with the Jews and the Christians related.
Exactly.
But I don't see where we would be able to do that, and I don't know to what end. I think we need to consider the question of whether Islam is actually religion. And I say that because if we were having dinner and I made for you a salad, and I had the salad in the bowl and I had the dressing and everything, and I went and got, you know, hypothetically 14% of the total contents of that out of my dog's dog food bowl, and I mixed in dog food with the salad. Now, you know, 86% of it is salad, and it's mixed all in now with dog food, and I serve it to you. So what have you eaten, if you decide to eat it?
That's, I don't think I'll eat your
Would you want to take and say, well, you know, I'm just going to pick apart out of here, you know, the non-dog food related stuff?
Yeah.
No, you're not. You're not going to be able to do that.
It's all contaminated.
I think we're at the place where we should consider, and I got into an argument just recently with a with a very well-versed attorney. And all joking aside, I think we ought to begin to think on what is authentic religion. In other words, I'll illustrate it this way. Take the concepts that came from Adolf Hitler. Clearly, we had millions of people who passionately followed these teachings. He didn't have any components of that would be religious, but let's say he did. Let's say he created some kind of a deity, and that's the burning noon.
That's the lunch whistle for the community.
Let's just say that he infused into all of that narrative, all that propaganda, some comments on a deity. Well, I think we're at the place where we need to examine if the practice of what you're calling religion has this effect, or causes this, or its goals are this, and we begin to line up things that would otherwise be considered sedition, or would otherwise be considered the erosion of civil liberties that are enjoyed by others.
Mm-hmm. Key point.
And we begin to construct a list of things and to say, I don't really care what you call it, but if the byproduct of the free exercise of it brings about these results, I'm prepared to say it's not. It's simply not. It's not protected behavior. It's not protected speech. It's something else. And I see in the future that we're going to find ourselves nearing that point where we're forced to begin to not take everything we are told at face value, and to begin to analyze what's really going on here. Should we listen to the words of our founding fathers? Should we consider that what is religious at all? It's really more about something else. And do we need to give it protected status? Do we need to continue to be silenced and not even say the word terrorist?
Right.
Do we need to be kowtowing to those demands in the school rooms and in the school board meetings and in the city hall meetings, and in regards to our flag, and in regards to our holidays, and in regards to all the things that make up our civil-bodied politic, what it is? I think we're heading down that road, and to that end, we need to give great consideration, in my opinion, as to the conversation that America begins to have with America. And not look to the media for guidance on that, but to look to truth, to be truth seekers, to be truth keepers.
Mm-hmm.
And
to learn our history.
And to learn our history, that's exactly right. America does have a conversation with itself. It truly does. And I think that conversation needs to take place and not be directed by agenda-driven directors. I didn't mean to get off on that. But
that's good, though. I think that's those are excellent points. We've got to look at what's the agenda. Faith is one thing. Faith doesn't have an agenda, but the others do.
Absolutely.
So that's a key word. Very good.
I think we need discernment as well.
Mm-hmm.
And I think we need to call on where we came from. We need to seek spiritual guidance from our Lord and Savior.
Yep. And begin to realize that our nation really was founded as a Christian nation.
There's no question about it.
Yeah. Chris, thank you so much for your time once again.
You're welcome.
And we will stay in touch, and we look forward to seeing you in San Angelo, July the 18th, I believe.
That's right. That's right. That's coming up.
That's right.
Looking forward to it.
Oh, great.
Thank you.
Thank you.